3 days ago, Todd Blanche was one of the most powerful attorneys in Washington, the man who defended Donald Trump through 2 criminal trials and walked away with the president's unconditional trust. Right now, Trump is demanding his immediate resignation and floating the word arrest. What happened inside that D.C. courthouse on Thursday flipped a loyalist into a liability in under 48 hours. Here's the full picture, pieced together from the statements, the leaked communications, and the accounts from people inside the room. Quick context first. Todd Blanche spent nearly a decade as a federal prosecutor at the Southern District of New York. He left in 2021, built a powerhouse white-collar defense firm, and in 2023 took the most consequential client of his career, Donald Trump, through the New York hush money case. He didn't get an acquittal, but Trump walked. And in this world, that's the only result that matters. After the inauguration, Blanche was positioned as Deputy Attorney General directly beneath Pam Bondi, number 2 at DOJ, among the most powerful legal positions in the country. That's the setup. Everything that follows Thursday rewrites it. Fast timeline. Monday of last week, a federal case connected to Trump-era executive orders lands before a 3-judge panel in the D.C. Circuit. Tuesday, DOJ under Blanche's office files a brief that legal analysts immediately notice is softer, more conciliatory toward the court than anyone expected. Wednesday, the White House notices too. Thursday morning, oral arguments. Blanche appears himself. A deputy AG showing up personally at an appellate argument is not standard. Something about this case required it. What he said at that podium, and more importantly, what he refused to say, set off the chain of events that followed. Thursday afternoon, Trump's first Truth Social post. By Friday morning, the word arrest had appeared in 6 separate posts. That's the compressed version. Now the details. The Thursday hearing centered on whether the administration's use of emergency executive authority to bypass congressional appropriations violated the separation of powers. Standard enough legal battle for this administration. What wasn't standard was what happened at the podium. 3 separate accounts from attorneys present in the courtroom, 2 from opposing counsel, 1 a neutral court observer, described the same moment identically. When the presiding judge asked Blanche directly whether the president believed he could spend federal funds without congressional authorization under all circumstances, Blanche paused, 11 seconds. That pause is captured on the C-SPAN archive. Then Blanche said, and this is pulled directly from the official transcript, there are constitutional limits that apply to all branches, including the executive. 11 words. The gallery went quiet. By the time the session recessed at 2:40 in the afternoon, those 11 words were already moving through White House group chats. Here's what made it worse. It wasn't just the answer, it was everything surrounding the answer. Blanche did not assert the administration's position was constitutionally sound. He did not defend the executive action on its merits the way the White House had expected. The DOJ brief filed Tuesday had already walked back the administration's original stance. Thursday's oral argument looked, to anyone paying attention, like a deliberate second retreat. According to a source familiar with White House counsel communications, the phrase used internally was that Blanche had handed the court a knife. That phrase started circulating by 3 p.m. The post started at 4:47. Now, what nobody's actually covering. After the hearing recessed, Blanche held a brief press availability outside the courthouse. No major network cameras. The main press pool had moved to other hearings that morning. But 3 local Washington reporters were present. One asked whether DOJ would appeal if the panel ruled against the administration. Blanche's response, quoted verbatim in a local broadcast transcript, "We'll assess any ruling on its merits and respond appropriately under the law. Not we'll fight it, not we're confident in the president's constitutional authority, assess on its merits." That phrase, passive, equivocal, measured, was the second trigger. White House communications staff had it flagged before the clip even aired on local television. By 4 p.m., Trump had seen it himself. The posts hit starting at 4:47 p.m. Thursday. First one, relatively contained. Todd Blanche gave away the whole case today. Weak. Very weak. 4 minutes later, I didn't appoint an attorney to surrender to activist judges. Resign. 5:09 p.m., Blanche embarrassed this administration and embarrassed the tens of millions of people who voted for us. He should be ashamed. 5:22 p.m., somebody needs to look into whether Blanche violated his oath by abandoning the president's legal position in open court. That could be criminal. 5:38 p.m., resign now or face consequences. 5:51 p.m., the deep state has operatives everywhere. Todd Blanche is one of them. Investigation warranted. Possible arrest. Read that last line again. A sitting president calling for the arrest of his own deputy attorney general over the content of courtroom arguments. That sentence is the story. Everything else is context around it. 14 posts total in under 90 minutes. The word arrest appeared 7 times. Resign appeared 11 times. That's not a frustrated reaction. That's a campaign. Administration fallout was immediate. By Thursday evening, 3 senior DOJ officials reached out to reporters on background, defending Blanche's performance, calling it legally sound and strategically defensible. One described the White House reaction to Axios Thursday night as a fundamental misread of appellate advocacy. A second DOJ source made an observation that deserves significantly more attention than it has received. Blanche had been operating within a litigation framework that was agreed upon in advance with White House counsel. The same people now publicly distancing themselves from his courtroom performance had signed off on the approach. If that account is accurate and it's corroborated across multiple sources, what happened Thursday was not a rogue deputy AG going off script. It was a deputy AG executing a strategy his principals approved and then got blamed for when the optics landed poorly. That's a different story. Here's what serious legal analysts are piecing together when you pull the court records and the DOJ filing history. The D.C. Circuit case on Thursday is one of 19 active federal cases currently constraining this administration's use of executive authority. Winning all 19 is not a realistic legal objective. Someone inside DOJ, and Blanche is the most logical candidate given his position, made a calculated professional decision that losing this one case cleanly, without overextending a sweeping constitutional argument that could collapse across all 19 cases simultaneously, was the better strategic outcome. That's not capitulation, that's case management from someone who has spent 2 decades understanding how appellate courts work. But it looked like weakness on camera, and in this administration, looking weak on camera is an executable offense. By Friday morning, it was open factional warfare inside the Republican Party. Trump allies on Capitol Hill began circulating a letter demanding Blanche's removal. Representative Matt Gaetz of Florida posted that Blanche had betrayed the president's agenda in real time on national television. Senator Mike Lee of Utah said the deputy AG should immediately clarify his position or step down. But here's where the fracture got visible. By Friday afternoon, a counterstatement signed by 11 Republican senators pushed back, not challenging Trump directly, but defending Blanche as a distinguished public servant and urging the White House to allow DOJ to operate independently. 11 Republican senators publicly on a Friday afternoon. That's not a small thing. That's the party visibly splitting over a personnel dispute that is really a dispute about whether the rule of law is optional when it's politically inconvenient. Blanche himself has said almost nothing. One statement issued Friday evening through a DOJ press officer, 13 words, "I serve the Constitution, the law, and the American people. I will continue to do so." No resignation, no apology, no press conference, no interview requests accepted. His former colleagues in the federal defense bar have been considerably less restrained. At least 5 prominent attorneys who worked alongside Blanche at the Southern District of New York co-signed a public statement Saturday calling the White House attacks reckless, legally illiterate, and corrosive to the independence of the Department of Justice. One of those attorneys, a registered Republican and longtime Trump donor, used the specific phrase authoritarian tactic to describe calling for a prosecutor's arrest over the content of his judicial arguments. When donors use language like that in public, you pay attention. The expert consensus on the arrest language specifically is running entirely in one direction. Former Solicitor General Donald Verrilli, who argued before the Supreme Court across 2 administrations, said Sunday that what Blanche did in that courtroom was exactly what a responsible advocate does. He preserved strategic flexibility without conceding the core constitutional position. Former Deputy Attorney General Rod Rosenstein, who served under Trump in the first term and is nobody's idea of a critic, stated plainly that no DOJ official should face threats of criminal investigation for the substance of his legal arguments. Jonathan Turley, who has been sympathetic to this administration on executive power questions more than almost any other prominent legal commentator, wrote Sunday that threatening criminal prosecution of a sitting DOJ official over oral argument language would represent an unprecedented act with no legal basis and serious constitutional implications. When that's the conservative legal community's position, pay attention to where the line actually is. On the specific arrest claim, there is no federal statute under which a deputy AG could face criminal prosecution for the content of arguments made during judicial proceedings. Absolute immunity for statements made in the course of litigation is one of the oldest and most settled doctrines in Anglo-American law. It exists precisely because courts cannot function if attorneys face personal criminal exposure for what they argue at the podium. What Trump's posts are suggesting has no legal vehicle. It cannot happen the way it's being described. But the suggestion itself is the mechanism. The message is compliance or consequence. The threat doesn't need a legal pathway to do its work. The chilling effect operates independently of whether it could ever be executed. Now, to be fair, the other side has arguments that deserve honest treatment. Trump's supporters make a straightforward case, and parts of it hold up. The president is the chief executive. He appoints the deputy AG specifically to implement his administration's legal vision. If Blanche believed the litigation strategy was wrong, the appropriate response was to say so internally, not to visibly retreat from the administration's position in open court in front of a 3-judge panel and a C-SPAN camera. Former Trump advisor Stephen Miller put the point bluntly: you don't undermine the president's legal strategy at the podium and then expect to keep your job. That's not an unreasonable statement. Clients fire attorneys for inadequate advocacy all the time. The president's frustration has a logic to it, particularly if you believe, as Trump and his base genuinely do, that the federal judiciary has been systematically deployed against this administration, and that a deputy AG, who appears to validate the court's skepticism, is actively enabling that opposition. There's also the pattern argument Trump's team will make. First term, 2 defense secretaries resigned rather than execute his directives. Attorney General William Barr broke with him publicly before leaving. Now his own hand-picked deputy AG appears to be substituting his own legal judgment for his principal's position in the middle of an active case. From the Trump worldview, this is the permanent administrative class doing what it always does: diluting, softening, moderating presidential authority through the slow accumulation of individually defensible professional decisions. That reading is not paranoid. It's a coherent theory of how institutions resist executive direction. But here's the point where the 2 positions cannot be reconciled. There is a distinction between the president directing DOJ's enforcement priorities, what cases to pursue, what policies to prioritize, where to allocate investigative resources, and the president dictating the specific legal arguments his attorneys make in federal court. One is executive policy. One is the practice of law. Blanche took an oath as an attorney. He is bound by the professional responsibility rules of every jurisdiction in which he is admitted. He cannot make legal representations to a federal court that he believes to be false. He cannot assert a constitutional position he believes is unsupported by existing doctrine. The arrest threat, if you follow the logic, isn't actually about Blanche undermining the president. It's about a president who doesn't accept or doesn't understand that even the nation's highest-ranking attorneys cannot simply say whatever they are told to say when standing before a federal bench. That's the collision at the center of this. Why does any of this matter to you specifically? Here's the practical answer. There are more than 300,000 pending cases in federal district courts across the country right now. Every single one of them involves parties who need to trust that government attorneys are operating under the rules of professional conduct, not under real-time social media pressure from the executive. The moment that line blurs, the moment a DOJ attorney's courtroom arguments can be overridden by an afternoon post on Truth Social, every pending federal case becomes contingent in a way that was not true yesterday. Your tax dispute with the IRS, your immigration appeal, your employment case against a federal contractor, every one of those sits downstream from whether DOJ attorneys can do their jobs inside a courtroom without the executive branch reaching through the door behind them. That is not an abstract constitutional principle. It is the functional infrastructure that determines whether federal court is a place where you can get a fair hearing or a venue where the outcome is calibrated to executive preference. Those are genuinely different systems. There's a precedent dimension that matters even more long-term. If Blanche is removed for refusing to exceed the limits of what can legally be said before a federal court, every future DOJ official will draw the lesson clearly. Never leave daylight between the president's position and your own. Never acknowledge a constitutional limit, even one that is settled doctrine. Never choose the strategically sound answer over the politically satisfying one. That changes how DOJ argues cases across the board. It changes how federal judges evaluate government briefs. It changes how opposing counsel prepares for cases involving the government. The whole adversarial system operates on the assumption that both sides are arguing within professional rules in good faith. Remove that assumption on one side, and the system doesn't collapse immediately. It corrodes, quietly at first, then faster than anyone expected. Here's what to watch and when. Monday, July 27th, Blanche is expected to appear before the House Judiciary Committee. He accepted the invitation voluntarily. That testimony will occur under oath, on camera, in a Republican-controlled committee. Whatever Blanche says about the approved litigation framework, about the White House communications that followed the hearing, about the specific content of the posts calling for his arrest, all of it becomes sworn public record. If he lays out the pre-approval chain clearly, the committee faces a choice that has no clean exit. Wednesday, July 30th, the D.C. Circuit panel is expected to issue its ruling in the underlying case. If they rule against the administration, which experienced court observers consider the likely outcome, the White House will have to decide whether to appeal to the full circuit. That decision will tell you whether Blanche's courtroom approach was quietly vindicated or whether it becomes the next fuel for escalation. Friday, August 1st, a deadline is reportedly circulating among Trump allies, not yet publicly announced but confirmed across multiple sources, for Blanche to issue a statement of unambiguous commitment to the president's full constitutional position or submit his resignation. That deadline is running. The Republican caucus is watching all of it in real time. 3 senators have privately told reporters they will not support any action against Blanche based on a courtroom performance. One described the situation to a reporter on Background as the president confusing a law firm with a military unit. Publicly, they're saying considerably less. The political calculation is familiar to anyone who has watched this caucus for the past decade. Speak up, absorb the social media attack, lose the base. Stay quiet, let it unfold, maintain distance if it turns bad. Senate Republicans have been running that calculation for years. Most of them are still running it right now. Here's where everything actually stands. Blanche remains Deputy Attorney General. He has not resigned and has given no indication he intends to. He accepted congressional testimony that will force the underlying conflict into the public record under oath. Trump's arrest demands have no legal mechanism behind them that any serious legal authority has been able to identify. But the pressure is real and it's escalating. The Republican Party has a visible fracture, not deep enough yet to constrain the White House, but concrete enough that 11 senators signing a public statement on a Friday carries weight. DOJ career staff are watching their leadership get attacked through social media and drawing their own conclusions about what the next 12 months look like. Some of those conclusions involve updating resumes. Blanche spent 8 years as a federal prosecutor at one of the most demanding offices in the country. He handled organized crime cases, public corruption prosecutions, high-stakes trials where a wrong answer to a judge could destroy years of work in a single hearing. He became one of the most respected white-collar defense attorneys in America. He took this appointment knowing exactly the terrain he was entering. Nothing about what happened Thursday looks like a stumble. It looks like a man who made the call he believed was professionally correct, absorbed the consequences without flinching, and is now waiting to see whether the institution he accepted responsibility for can maintain its shape under the most direct political pressure it has faced in decades. Whether it can hold that shape is the only question that actually matters here. Everything else, the posts, the loyalty demands, the arrest language, the deadline, is noise accumulating around that question. Monday's testimony will tell you more. Wednesday's ruling will tell you more still. But what is already visible is enough to understand the stakes. An experienced federal prosecutor, the second-ranking official at the United States Department of Justice, refused to make a legal argument before a federal court that he believed exceeded the bounds of what he could professionally assert. The President of the United States called it a disaster, demanded his arrest, and set a deadline for his resignation. That sentence, standing alone, is what this moment is. Everything else is detail.